Imagine a law, basically gathering dust for over 2 centuries. Suddenly, boom, it's back. It's being used in a way that's really unprecedented, impacting real people right now. Today on The Deep Dive, we're plunging into a very recent Supreme Court decision. And it's ignited this, well, furious debate about executive power, about due process, that fundamental fairness idea, and really how our legal system tries, or maybe struggles, to keep up with actions that feel new. Welcome to The Deep Dive. Our mission here is always the same. Cut through the dense legal stuff, unpack complex information from different sources today. It's this really key Supreme Court opinion and give you the essential insights, the stuff you need to really get it. So our specific focus today, a Supreme Court case dealing with the president invoking something called the Alien Enemies Act. It's pretty obscure. Very obscure. And it was used to detain and facilitate the removal of Venezuelan nationals, people suspected of being members of Tren de Aragua, or TDA, which the administration has labeled a foreign terrorist organization. Yeah. Now, our goal here, just to be clear, isn't taking sides. It's about understanding the arguments, the kind of surprising history behind this, and the real-world human impact of this incredibly fast-moving legal fight. Okay, let's unpack this.
Well, what's really fascinating here, and frankly pretty alarming to a lot of legal folks, is just how specific and rarely used this law is. We're talking about the Alien Enemies Act, the AEA. It first became law way, way back in 1798. I mean, think about that context.
1798?
Yeah, the young U.S. was terrified of war with France. And this act, it was designed very explicitly for wartime. It gives the president power to detain and remove citizens of a hostile nation, but only, and this is really key, when there's a declared war or a direct threat of invasion or predatory incursion.
And when you say rare, I mean, just how rare are we talking? This isn't like a go-to law for presidents, is it?
Oh, not at all. Not even close. Before this current situation, presidents had used the Alien Enemies Act only 3 times. Ever.
3 times in over 200 years.
Exactly. During the War of 1812, World War I, and World War II. And here's the critical thing. Every single one of those times was smack in the middle of an ongoing, formally declared war. It was aimed at citizens of nations we were actually officially fighting.
Okay, so that deep, rarely touched history really sets the stage for what happened recently. March 14, 2025, President Trump issues Proclamation 1903, its stated purpose to address what it called an invasion of the United States by Tren de Aragua, described as this Venezuelan criminal group. Now, okay, here's where it gets really interesting and where the legal fight truly kicks off. You just said the law was for declared wars with nations.
Right.
But there's no declared war with Venezuela. And TDA, Tren de Aragua, it's not a nation, right? It's a gang, a criminal organization. So how does the proclamation even try to justify using this specific 1798 law?
Well, it tries to, let's say, stretch the definition. It asserts that TDA is, and I'm quoting here, undertaking hostile actions and conducting irregular warfare against the territory of the United States. So the argument is essentially that the actions of this group, even without a declared war against Venezuela itself, feel like that predatory incursion or invasion the old act mentioned.
Okay, so it's focusing on the actions, calling it irregular warfare.
Exactly. And then the proclamation does something else really crucial. It defines alien enemy specifically for this situation. It broadens the term way beyond just citizens of a warring country. It says it includes all Venezuelan citizens 14 years of age or older who are members of TDA, are within the United States, and are not actually naturalized or lawful permanent residents. So it targets people based on alleged gang membership, not just nationality in a declared war.
That seems like a really significant expansion, right? Applying a wartime act based on alleged gang affiliation in peacetime.
Yeah, it's the core of the legal challenge, and it led directly to the immediate crisis that pushed this whole thing up to the Supreme Court so fast.
What was that immediate crisis? What actually triggered the lawsuit?
This is where you get into some very serious allegations, especially highlighted by the dissenting justices later on. They point to claims about the government's actions before the lawsuit was even filed. According to the dissents, DHS, the Department of Homeland Security, allegedly started moving Venezuelan migrants, people potentially targeted by this future proclamation, to the El Valle detention facility in South Texas before the president even signed the proclamation on March 14th.
Wait, before the law was even officially invoked?
That's the allegation, which, immediately raises huge questions about due process.
Okay, let's pause there. Due process. We hear that term a lot. For listeners, what's the simple version? What does that mean right here?
At its heart, due process means fairness. It's the government having to follow fair procedures and respect your legal rights before it takes away something major, like your liberty, or in this case, before removing you from the country. You need notice of what you're accused of, a chance to be heard, access to counsel. Basic fairness.
Okay.
And the dissent claims these migrants were moved, told they'd be deported, but without knowing why, and crucially, without a chance to call lawyers. One lower court judge actually used the phrase that the government seemed to be hustling people onto those planes to potentially avoid court orders or prevent them from getting a habeas hearing.
Hustling people? That's strong language from a judge.
It is, and it underscores that this isn't just about abstract legal points, it's about individuals caught in the middle.
And the dissents actually mention specific stories, don't they, to put a human face on this?
They do, and they're quite striking. For example, there's plaintiff JGG. He was accused of being in the gang because of his tattoos. Yeah. But he explained he's a tattoo artist, and he got this specific eye tattoo because, quote, he saw it on Google and just thought it looked cool.
Wow. Accused based on a Google search tattoo.
And then there's plaintiff GFF, accused as an associate just because he was at a party. A party with strangers he says he only went to because a friend insisted.
Just being at a party.
These examples really drive home why having a fair, transparent process is so vital, especially when you're talking about using a law this old and this powerful based on these kinds of associations.
So, faced with these alleged deportations happening super fast, maybe without due process, lawyers jumped in. They filed a class action lawsuit in Washington, D.C.
Right, a class action representing a group of people facing the same situation.
And they argued, basically, that the whole thing violated the Constitution's due process clause, and that the president couldn't even use the Alien Enemies Act like this. But crucially, they weren't asking for people to be released immediately, right?
Correct. Their initial goal was just to stop the deportations, hit pause, essentially, so the courts could figure out if this was legal before people were removed.
And the D.C. District Court responded quickly.
Very quickly. On March 15th, the day after the proclamation, the court issued temporary restraining orders, TROs.
Okay, TROs, that's like an emergency stop sign from the court.
Exactly. A short-term order to freeze things, stop the deportations for the named plaintiffs, and a provisionally approved class, just to maintain the status quo until they could have a more thorough hearing.
But then, the government's actions allegedly continued. This is where it gets really contentious.
According to the dissenting opinions, yes. There are allegations that even after the lawsuit was filed and the court hearing was scheduled, the government kept loading people onto planes for immediate departure. The D.C. Circuit Court of Appeals then refused the government's emergency request to pause those TROs. So you had the lower courts basically saying, whoa, hold on, we need to look at this before people are sent away.
The lower courts saw an emergency, tried to pause things, but then it gets kicked up to the Supreme Court, and they did something different.
That's right. It went up to the Supreme Court on an emergency basis, and on April 7th, 2025, the court issued what's called a per curiam opinion.
Per curiam meaning by the court, no specific author named.
Correct. And in that opinion, the majority vacated the D.C. District Court's TROs. They essentially lifted the pause on deportations ordered by the lower court.
Why? What was their reasoning for overturning the lower court's emergency stop?
Their core legal reason came down to procedure, specifically where and how these challenges should be brought. The majority stated that challenges to removal under the Alien Enemies Act must be brought using habeas corpus.
Okay, habeas corpus, we hear that term. Can you break that down simply?
Sure. Habeas corpus is a fundamental legal protection. It basically means you shall have the body. It's a petition you file to challenge your imprisonment or detention, forcing the government to justify to a court why it's holding you. It's about unlawful detention.
Got it. So, a specific legal tool to challenge being locked up.
A very specific tool. And crucially, there are rules about where you can file a habeas petition.
Ah, the venue issue.
Exactly. The Supreme Court majority said that for these core habeas petitions challenging detention, the case belongs only in the court district where the person is actually confined, since many detainees were being held in Texas.
The lawsuit filed in D.C. was in the wrong place, according to the majority.
That was their conclusion. Improper venue. So while saying people could challenge their detention, they said the D.C. court wasn't the right court to hear it. It had to be done via habeas in the district of confinement.
But, and this seems really important, the Supreme Court, the majority, and even the government in their arguments, they did agree that these individuals are entitled to judicial review, right, and due process.
Yes. That's a critical point of agreement across the entire court, including the dissenters. Everyone agreed that people subject to removal under the AEA have a right to challenge it in court judicial review and are protected by the Fifth Amendment's Due Process Clause.
So it wasn't if they get a hearing, but where and how.
Precisely. The court's opinion stated detainees must get notice after this ruling that they're subject to removal, and that notice has to be timely enough for them to actually file that habeas petition in the proper court before they're removed. So if you step back, all 9 justices agree review is necessary. The fight is about the pathway. Only habeas, only in the district of confinement, the majority view, versus potentially other claims or venues. It seems procedural, but it really shapes access to the courts.
Right, channeling everything through that specific, potentially harder to access habeas route.
It can be, yes, especially when things are moving quickly.
Okay, now let's get into those dissenting voices. They sounded some loud alarms, didn't they? Justice Sotomayor wrote a main dissent, joined by others. What were their big concerns?
They had several very serious concerns. First, Justice Sotomayor hammered home the point that using this wartime law, the AEA, in peacetime against members of a criminal group, not citizens of a warring nation, was simply unprecedented.
Back to that core issue.
Right. And then she really focused on the government's alleged conduct. She accused the administration of covert preparation to skirt both the law's requirements and the Constitution's guarantee of due process. She repeated that phrase about the government potentially hustling people onto those planes to avoid court review.
And there was that issue with planes allegedly landing in El Salvador even after the court order.
Yes. The dissent noted the district court was still investigating whether the government ignored its order to return planes that were already in the air, planes that allegedly ended up landing in El Salvador.
Now, the dissent mentioned a legal idea. He who comes into equity must come with clean hands. Can you unpack that? Why bring that up here?
It's a fundamental principle, mostly in civil law, meaning if you're asking a court for fairness, equity, you yourself have to have acted fairly and ethically in the situation. The dissent was essentially arguing, if the government acted improperly here, maybe by trying to rush deportations to avoid court orders, should the Supreme Court really step in and give the government the emergency relief it wanted by vacating the TROs? It questions whether the government deserved the court's help, given the allegations.
That's a powerful point. And the conditions in El Salvador, that was another major concern for the dissenters, bringing it back to the human cost.
Absolutely. The dissent painted a grim picture of the facility there. See ECOT, the Center for Terrorism Confinement. Citing the record, it mentioned detainees being highly likely to face immediate and intentional life-threatening harm, being denied communication, facing severe overcrowding, lack of food and water,
Oh, wow.
and a horrifyingly high death rate, with estimates of around 375 deaths in Salvadoran prisons since March 2022. The dissent argued sending people there without proper review creates a massive risk.
And what about getting someone back if they were sent there by mistake? The idea of irreparable harm?
That was perhaps the most chilling point. The government apparently took the position that it cannot retrieve people once they are sent to CECOT.
Cannot get them back, even if the U.S. made a mistake.
That's what the dissent states the government argued, which raises this specter of irreparable harm, a harm that can never be undone. If someone, even potentially a U.S. citizen mistaken for someone else, gets sent there, there might be no way back. That finality deeply troubled the dissenters.
Beyond the human impact and government conduct, the dissent also attacked the majority's legal reasoning, right? Starting with whether the Supreme Court should have even taken the case at that stage.
Yes, they questioned the court's jurisdiction, its authority to even review a temporary restraining order like this on an emergency basis. They argued it wasn't a true emergency for the government because the lower courts were already handling the case through the normal process. Why the rush for Supreme Court intervention?
So, challenging the emergency nature of the government's appeal.
Exactly, and they strongly disagreed with the majority's conclusion that habeas corpus is the only way to challenge these removals under the AEA. Sotomayor called that conclusion novel and dubious.
Why dubious? Were there other ways before?
Historically, yes. The dissent pointed out that challenges to deportation orders could often be brought under the Administrative Procedure Act, the APA, which governs how federal agencies operate. They argued the majority was shutting down established legal pathways without proper justification.
And that ties into another major criticism from the dissenters of the process the Supreme Court used.
Yes, a huge point for all the dissenters. They were deeply troubled that the court was making such a significant ruling on a complex issue with, as Sotomayor put it, Bare bones briefing, no argument, and scarce time for reflection. Basically deciding too much too fast.
Justice Jackson also wrote separately reinforcing that concern.
Very much so. Justice Jackson called it a fly-by-night approach, criticizing the majority for jumping in right before the district court's planned hearing without scheduling oral arguments or getting full legal briefs on the merits of the case.
She had that really stark line, didn't she? Something about liberty. Yes, the president invoked a centuries-old wartime statute to whisk people away to a notoriously brutal, foreign-run prison. For lovers of liberty, this should be quite concerning.
It's powerful language, and she connected this rushed process to the court's emergency docket, sometimes called the shadow docket, where these quick decisions happen with less transparency. Her argument was that cutting corners on the usual process, full briefs, oral argument, deliberation, drastically increases the risk of error. She even brought up the infamous Korematsu case.
The Japanese internment case from World War II.
Exactly. A decision now universally condemned, which she implied was also a product of rushed decision-making based on fear. Her point was a warning. Speed and lack of deliberation by the highest court, especially on issues of liberty, can lead to grave mistakes.
So wrapping this deep dive up, it's clear we have this unusual situation. On one hand, complete agreement from all 9 justices that people being removed under this old act do get judicial review. They do have due process rights.
Unanimous on the principle.
But then this deep split on the how and the where must it be habeas corpus? Must it be only in the district of confinement? And layered on top of that are these really serious concerns from the dissenters about the process the court used, the government's alleged actions, and the potential human consequences.
Absolutely. And this whole case, it really underscores why these seemingly technical legal details matter so much to you, to everyone. This isn't just law school stuff. It's about your fundamental rights, how government power is checked, and how laws written centuries ago can suddenly affect lives today. The fight over the procedure, where and how you challenge the government, is often just as critical as the right to challenge it in the first place.
Right. So maybe the final thought to leave you with is this. We live in this age of, rapidly changing global threats, instant information, blurring lines between war and other kinds of conflict. How do we make sure that these really old, powerful legal tools, like the Alien Enemies Act, are used with the kind of care, the deliberation, the fairness, the due process that we expect today? Especially when people's freedom, maybe even their lives, are hanging in the balance. It really pushes us to think about that delicate balance. Executive power, the court's role in reviewing it, and the fundamental rights of individuals, particularly when the government perceives a crisis. Lots to think about there.